Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye.
A has looks like a 4 or 5 point question here. So let's kind of jump in. If medical records reveal a PA, physician's assistant, has input on all, 5.5 on all sensory motor tests for lumbar radiculopathy, but performed 0 tests, that be included in a letter range for request, an amendment to other correct non-performance, and incorrect PT PAC report. This is a pain clinic. Okay, so I kind of big picture, I think what you're asking is there is a medical report that, and I'm assuming that when you say 5.5, meaning that you have full capacity to do certain things. And yet you're saying that there was no tests done and that this conclusion is erroneous because no tests were done. And what should you do? Steph, what would you say? What would you tell somebody to do in that situation?
Yeah, it's disturbing. I hear this a lot every day. I feel like cut and pasted, the defaults on these computerized ways they put in their records default to within normal limits, perfect, probably 5.5.
Yep.
And it's frustrating because it's inaccurate. I hate to say the word defamatory, but it kind of is, because it's false information that's going to financially damage somebody if someone were to believe it. Even though this is just one small piece of your case, you can ask for it to be fixed. I think pretty much in every state, don't they have a right to ask it be fixed?
Yeah, I know that I've had people tell me they've contacted their doctor to say this needs to be fixed, and the doctor refuses to do so. I think SA may be suggesting, should I contact or should I write a letter to the judge or the adjudicator and let Social Security know that? And again, certainly as an attorney, if somebody tells me this is inaccurate, I would in my brief say the claimant will testify that this report is inaccurate. A lot of times the consultative evaluation that no tests were done, that the doctor didn't touch the person or didn't do any sort of test, and they can talk about that. Realize a judge may or may not believe you.
Right.
Medical records are medical records, and judges many times will believe what the doctor says over what you say. Although, again, if it's an industrial clinic type of place, you can certainly make that argument. So I think really, and I think what you said at the beginning is really important, that this is one part of a big picture. And if it's not consistent with everything else, what I would probably do is I would, in a pre-hearing brief or in a letter to an adjudicator, say, information, I've reviewed it, this is inaccurate. I've asked the doctor to change it. The doctor will not change it. However, saying these tests are all within normal limits or 5 out of 5, there's no way, because there was no test done. And, I'm disputing that. And, whether they believe it or not, I can't tell you whether a judge will buy it or whether an adjudicator buys it or not, but you can certainly try to do that. And this is really, as lawyers, a lot of times, and just to kind of go broader than what we're talking about in Social Security, every case, if you go to state court or federal court, there are going to be differences of opinion, differences of fact, and a fact finder has to make the decision as to what's most accurate. So, and again, let me just throw this out as well. Maybe this person who did this PA is looking at other records. I mean, who knows where they came up with it? But I do think if you make noise about it and you object to it, both to the doctor and to the Social Security, and you send a copy of the letter from the doctor, I think that many judges would feel like, well, if you're going to go to all the effort to contest this, there must be a grain of truth there. So that's how probably I would handle it.
And it happens. I see on consultative exams sometimes my people will say, because I usually share the exam with them, most people want to see it. And I'll say, is there anything in there that is factually incorrect, not discretionarily or diagnosis or anything like that? For instance, if they said he could do the heel to toe walk, but he was never asked actually to do the heel to toe walk, and the doctor's saying he can do it. That's kind of a false fact. You know what I mean? Right. Similarly, if he's, sometimes they'll say in the record that she can zip, button, and tie, so the hands are good. And I'll say, were you asked if you could zip, button, or tie? No. Did they have you zip, button, and tie? No. And so there was nothing that came up about it. And if it's a finger case where, I'm always big about the fingers, like it may not be your main impairment, but boy, it can really cut out a bunch of jobs if you have even minor finger arthritis or whatever, or carpal tunnel or what have you. And so when the doctor is using his canned template for these consultative exam reports, and it always says they can do this because he just never changed it and made it accurate and never even tried. Or similarly, can hop, had no problem hopping on or climbing upon the examination table. And the person's like, he wasn't in the room when I was in there. They put me in the room and I did it myself. Like he did it himself, but it doesn't mean he didn't have a problem because there was no one there to witness. So all sorts of weird things.
Just to kind of put a bow on this, because I don't want to spend too much more time on this question, but at the end of the day, the MRI report is a lot more important than what some doctor says or PA says about your ability to do heel to toe walking. So, give it the importance, the relevance that it deserves. An MRI showing a badly herniated disc with, nerve compression is going to be a lot more relevant than some of these neurological tests.
Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good afternoon or morning. I'm just going to do a quick share. I was dealing today with a medical provider response to a client's first party high-tech HIPAA request for his medical records. They happen to be mental health records. But anyway, they were very prompt in responding to him, saying that they had to decline providing the records because he did not state a purpose he wanted his records in his HIPAA request and release. Now, aside from the fact that I don't think he's obligated when it's a first-party request to give a purpose, so I don't think they can demand it of him. But I don't have the time today to go find out where I knew that from, which would probably be either in the HIPAA statute itself, or it might have been a statement by HHS. I don't know. That's something I got to look into. But in any event, it did remind me to start looking a little bit. So I put like 10 minutes in. But here's something that I really wanted to share, because I hear so many of you and my clients get really, really upset because there are so many errors in the medical records. There can be outright untrue things, inaccuracies. Sometimes it's from cut and paste. Sometimes it's mixing up people. Sometimes it's just flat out misinformation. And if it's material, it could be damaging to their, in theory, their future health treatment, but also to their legal case. So what is the deal about when that happens? You do have an absolute right, I think many of you might know this, to demand, or I should say request, that the medical provider fix the inaccuracies. So how do you go about doing that? Well, generally it's got to be in writing. So I'm just going to give you a little blurb that was provided by a company or a website called medsafe.com. And I thought it just kind of reiterates this. It says, when patients access a medical record and discover information they believe is inaccurate, they must file a written request for the record to be corrected. And I believe this is under HIPAA. The covered entity must then respond to the request within 60 days. And I realize that might seem like a long time, guys. It may take an additional 30 days, but must provide a written explanation for the delay and a date of completion. So if you want your medical records corrected, what I would suggest, obviously you have to do it in writing. And I would probably attach the actual pages and circle what's wrong and explain why this line is wrong and what would be the accurate statement. I did this once. I think I didn't even do it in writing. It had something to do with my child and pets in the house, and my child had asthma. And there was a mistake that I thought was material because it could look like we were being remiss with regard to keeping our newly diagnosed asthma child out of harm's way with close proximity to animals. Anyway, it did get changed. But what they tend to do is say something like, patient's mother stated that this was incorrect and that, in fact, the animals are kept in a separate location, blah, 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 or something like that. So obviously they cannot attest to whether my animals, where they are. They can only report what I reported, since that's something that happens at home. So for more medical record statements, and it could be whatever it may be. It could be something that they say you said that you didn't say, or they misunderstood what you said and wrote it down wrong. And in some shape or form, it's not favorable to you, or it could be unhelpful or damaging or whatever. I'd go ahead, I would probably send it in a way where I have confirmation of how it was sent. I'm thinking by fax is fine, and then you have a fax confirm, and then diary that date so that you look at 60 days and see if they've responded to you. And if they haven't, perhaps that would be something that would be maybe keep nudging them. But now you've proved that you've tried to get them to correct it yourself, and then maybe you can go and take it up the line. But I think when it's something very material, you probably should do it, because that's going to stick in your record for years. And depending on the nature of that inaccuracy is how important it will be to you to get it fixed. So anywho, they do have a deadline to respond to your request to correct the medical records. If you do it only verbally, I think most people are going to be out of luck. You'll be mentioning it to someone who has no clout, no authority, and no power to do it. So if you do it in writing, it probably goes to the correct office, because I think they know they can get in trouble if they don't respond. I mean, a HIPAA violation, perhaps. Okay? Ciao for now, guys. Later.